If you work on offshore oil rigs and you get injured, there are two different federal laws that might apply to your case, and the difference between them could be worth millions of dollars. The problem is, most offshore workers don't know which law covers them. Their employers certainly won't explain it, and the insurance companies will try to force you into whichever system pays you less money. I'm maritime injury attorney Matt Schaefer, and in this video, I'm going to break down the difference between the Jones Act and the Longshore Harbor Workers Compensation Act and help you figure out which one protects you if you're injured working on an offshore rig, because getting this wrong could cost you everything. The basic difference: the Jones Act covers seamen, maritime workers who have a substantial connection to a vessel in navigation. If you qualify as a seaman, you can sue your employer for negligence, get pain and suffering damages, choose your own doctors, and recover full compensation with no caps. The Longshore Harbor Workers Compensation Act, known as the Longshore Act, covers maritime workers who don't qualify as seamen. It's similar to workers' compensation, but with slightly better benefits. You get medical coverage and about 2/3 of your wages while you're disabled, but you can't sue your employer, and there's no pain and suffering damages. The difference in money is massive. A back injury that gets you $200,000 under the Longshore Act might be worth $3 million under the Jones Act. So which law covers offshore rig workers? This is where it gets complicated. Offshore rig workers can fall under either law depending on exactly what they do and what type of rig they work on. Jones Act seamen include crew boat operators. If you operate vessels that transport workers and supplies to and from offshore rig, you're definitely a Jones Act seaman. If you work on vessels that deliver equipment, food, fuel, and other supplies to offshore rigs, you're a seaman. If your rig moves from location to location, you're part of that crew that operates or maintains the rig, you're likely a seaman. Drill ships are vessels, and their crew are seamen under the Jones Act. Longshore workers include workers on fixed platforms. If you work on a rig that's permanently attached to the ocean floor, you might be covered by the Longshore Act instead of the Jones Act. If you're flown out to a rig to do a specific job and then leave, you might not have enough connection to qualify as a seaman. If you work in an office on a rig but don't contribute to the vessel's navigation or operation, you're probably a longshore worker. But here's where it gets tricky. The line between Jones Act and longshore coverage isn't always clear. The same worker might be covered by different laws, depending on what type of rig you work on. Floating rig workers are more likely to be seamen. Fixed platform workers are more likely to be longshoremen. If you're transported by vessel and you do your work on the vessel during transport, that supports seaman status. If your work contributes to the operation of a vessel, you're more likely to be a seaman. The more time you spend on vessels and navigation, the more likely you are to qualify as a seaman. I've seen cases where oil rig workers doing identical jobs were classified differently because one worked on a floating rig and the other worked on a fixed platform. Why does this classification fight matter? Let me show you the difference with a real case example. Two offshore workers suffered identical back injuries requiring surgery. Both were the same age, made the same salary, and had similar long-term disabilities. Worker A was classified under the Longshore Act. He received his medical bills being covered, $1,200 per week in disability benefits for 2 years, $180,000 in permanent partial disability benefits, total compensation about $300,000. Worker B was classified as a Jones Act seaman. His case included medical bills being covered by the employer, full lost wage compensation, pain and suffering damages, lost future earning capacity, for a total settlement of $2.8 million. Same injury, same worker profile. The only difference was which law applied. That classification was worth $2.5 million. And your employer and insurance company will manipulate the classifications. Here's what happens in the real world. Employers and insurance companies will argue that you're covered by whichever law pays less money. If you're clearly a Jones Act seaman, they'll argue that you're actually a longshore employee. If you're clearly a longshore worker, they'll actually never argue you're a Jones Act seaman because that would cost them much more money. Common arguments your employers will use. You work on a fixed platform, so you're a longshore worker, not a Jones Act worker. But if you get to that platform by vessel and you did work on that vessel during transport, you still might be a seaman. You're a contractor, not a crew member. but the temporary worker can still be a seaman if they contribute to vessel operation. You spend most of your time on the platform, not on vessels. But even if you're only 30% of your time is spent on a vessel, you might still qualify as a seaman. These arguments are often wrong, but most injured workers don't know enough maritime law to challenge them. To properly classify your case, a maritime lawyer needs to investigate your work duties, what exactly you did. Did your work contribute to vessel operations? The type of equipment, was it floating or fixed? If it is floating, you're more likely to be a seaman. How you got there? Did you travel by vessel? Did you do work on the vessel during transport? What percentage of your time was spent on vessels versus platforms? Were you hired as a crew member or as a contractor? How were you classified on company documents? How have courts classified workers with similar job duties in other cases? Here's a real case example. I represented a maintenance worker who was injured on what appeared to be a fixed offshore platform. The insurance company immediately claimed he was a longshore worker, offered him about $250,000. But we investigated and discovered several key facts. The fixed platform was actually a semi-submersible that was moored but could be moved. The worker's job included maintaining the dynamic positioning system that kept the platform stable. He was transported to the platform by crew boat and did maintenance work on the crew boat during transport. He lived on the platform for 2-week rotations and was considered part of the platform's operating crew. Based on these facts, we successfully argued that he was a Jones Act seaman. His case settled for $1.9 million instead of $250,000. So if you're injured on an offshore rig, don't accept anyone's initial classification of your status. The company will immediately start processing your claim under whichever system benefits them the most. Document your job duties. Document how you transported to the rig. This information will be crucial for determining which law applies. Don't sign any forms that acknowledge a specific classification until you've had your case reviewed by a maritime lawyer. Get medical attention immediately and choose your own doctors if possible. Remember, you may have claims under both systems. Some workers are covered by the Longshore Act for their primary employment, but have Jones Act claims related to a vessel work that they did. The stakes are too high to guess. Look, I know maritime law is complicated. The difference between the Jones Act and the Longshore Act can be technical and confusing, but the financial stakes are too high to just accept whatever classification the insurance company gives you. I've seen too many offshore workers leave millions of dollars on the table because they didn't understand which law applied to their case. I've seen insurance companies deliberately misclassify cases to save money. Don't let that happen to you. If you've been injured working on an offshore rig, you need a lawyer who understands these classification issues and will fight to get you covered under the law that provides you the most protection. Which law protects you? The answer depends on your specific job duties, the type of rig you worked on, and how you were transported to work. Here's what I can tell you for certain. If there's a reasonable argument you're a Jones Act seaman, it's worth pursuing. The difference in compensation is too large to ignore. If you're clearly a longshore employee, you should still understand your rights under that system and make sure you're getting full benefit. Either way, you shouldn't trust the insurance company's initial classification. They have every incentive to minimize your benefits. If you work offshore and want to understand which law protects you, watch my video explaining what the Jones Act is and how it works. And if you're injured and want a professional evaluation of which law applies to your specific situation, there's a link in the description for a free consultation. We handle these cases nationwide. We only get paid if you win, and we'll fight to make sure you're classified under the law that provides you the most protection and compensation. Don't let a wrong classification cost you millions of dollars. Know your rights under maritime law.